Tice Madox Solicitors is results-oriented, but with a distinctive approach tailored to our clients' needs in our specialist fields: immigration law, criminal law, employment law, commercial law, family law, and contracts law. We are well equipped in our litigation and advocacy for the benefit of our clients, corporates, and individuals. Why not visit us at 5 Oakfield House, Oakfield Road, Ilford, London, IG1 1EF. We are just 15 minutes from Liverpool Street Station. Tice Madox Solicitors. Try us. We are professional.
Hello and welcome to the program. My name is Justice Maduforo. I'm a solicitor of the Senior Court of England and Wales. I'm also a barrister and solicitor of the Supreme Court of Nigeria. Tice Madox Solicitors brings the best topics, and the purpose of this program is to kickstart your consciousness to law, be it in immigration, criminal, contracts, family law, in all areas of law, employment matters, and all the matters that concerns you. So this program kickstarts your consciousness and points you and signposts you to the right place. When you go to the right place and get the right information, you have solution. So therefore, this program is packaged in such a way that points you to the right place. I will be discussing the topic today. My topic today will be home office policies. Home office policies / interpretation. Home office policies / interpretation. I take it this way, home office policies. Ladies and gentlemen, home office is that body, as you know, without explanation, that handles the issues of migration and security of the United Kingdom. Issues of external security in terms of those who are coming by way of immigration, and internal security by way of the policing of the United Kingdom and the rest. In accordance with the Act establishing or the laws establishing the Home Office, and in subsequent decisions and subsequent rearrangement of Home Office have divided itself, one arm that deals with enforcement and one arm that deals with immigration. And enforcement that deals with those, removing those outside of the United Kingdom, for those who are in the United Kingdom, removing them out of the United Kingdom. And the other arm, which is immigration, that deals with those who are in the United Kingdom making applications only for the purpose of remaining in the United Kingdom or entry into the United Kingdom. Now, in accordance to deal with those powers enshrined under it and granted to Home Office, the Home Office makes policies when it comes to immigration applications. When it makes these policies and guidances, and they are in tandem, in line with the rules, which mean the rules that have been tabled before the Parliament and approved by Parliament. These policies go pari passu. They go together, hand in hand with the rules which have been passed by Parliament. In accordance with that, they sit together. And as a result of fact, and as a matter of fact, the policies interpret the rules. And the policies and guidances of the Home Office shapes the rules. In the process of doing so, the policies overlap to the rules, and sometimes in conflict with the rules. And it sometimes does not tally well with the rules or the statutes. And also sometimes does not tally with the case laws which has been released and chunked out and decided by courts of record, which is the upper tribunal upwards to the High Court, to the Court of Appeal, to the Supreme Court, and to the European Court of Justice, as it is now that United Kingdom is still within the EU. That is the stage. So these different arms, which is the European Convention on Human Rights, which is the Article 8 and the rest of them, or all articles, shape the policies of the Home Office, shapes the statutes, and at the same time shape the case laws, which has been released. Now, these Home Office policies are what determines your application, whether it succeeds or it fails. And the courts of record, from the first tier tribunal to the upper tribunal, must in determination of applications or appeals before it, must always marry together the policies of the Home Office in line with the rules, which is the immigration rules. These immigration rules keep on changing, either for good or for bad. And sometimes these immigration rules are also interpreted by the Court of Record, either by the Court of a Tribunal or by the Court of Appeal, the High Court. Now, when they make these decisions, it shapes the policies and guidances of which the Home Office have to amend their policies and guidances to suit and to tally together with the interpretation of the Court of Record in relation to that policy, guidance, or the immigration rules. So that is why immigration law is so dynamic and evolving. Immigration laws and immigration rules are a matter of dynamism because of the case-by-case basis that's presented to the Home Office caseworkers and the case-by-case basis that are presented before the court or the tribunal. Then in making such decisions, those case-by-case bases are taken into account to now produce a steady and consistent decision that will amend or shape the policies, or that will conform with the policies of the Home Office, or that will shape completely or appeal or repeal the policies of the Home Office. So it's important. That is why, as a practitioner in immigration rules and other areas of law, laws are ever dynamic, ever evolving, ever flexible. That is the law. And therefore, your accounts cannot be the same with the account of A, B, or C. You are peculiar in your circumstance. B is peculiar in his or her circumstance. C is peculiar in his or her own present circumstance. And that is why I always emphasize that what you hear on this program is not legal advice, but rather it kickstarts your consciousness, jogs your mind to bring your circumstance into great and consistent scrutiny to see that your case-by-case basis will be sufficient to make a proper and possible and perfect argument before the caseworker of the Home Office or before the tribunal or the court. Ladies and gentlemen, that is why when you call to seek legal advice, we will always invite you to come to the office, or at best, some of you who are far away cannot come to the office, to have an appointed time to take instructions from you over the telephone, detailed instruction, subject to having documentations that whether you have sent it to us by email or by fax or by post, so that we can read them and then take detailed instruction, streamlining your case-by-case basis as it goes along. And in that case, removing it, completely sifting it out from the previous decisions that made decision, even if that decision was not in your benefit or similar to yours, and was an adverse decision in the past, but your case-by-case basis will amend it. That is why I can authoritatively tell you this, that upper tribunals, High Court of Justices, Court of Appeals, Supreme Court decisions, when they make decisions, that decisions are not infinite. The decisions are always coined with the word case-by-case basis. So a decision they make is as a result of the case or the circumstance of that appellant that has come before them. So they may make decisions in the favor of the appellant, or may make decisions in the favor of the Home Office that is challenging or that is appealing. So as a result of that, such decisions, you may not take it straight to the bank, but surely some of the wordings and the dictums of the learned judges will be crucial in determining and injecting into your present circumstance to see whether or not decisions that are chunked out could be in your own merit and in your own good. And that is why at Tice Madox Solicitors, myself, with the eagle eye, will streamline and macroscopically look into the court's decisions from the first chapter to the last chapter, from the first number to the last number, to the first paragraph to the last paragraph, look at it and lift decisions or dictums or wordings, even if they are, by the way, as I say, that's what dictum of the judges, even if they are, by the way, decisions that does not go into the heart of the decision which is in question, but those dictums are relevant and crucial. They are crucial to continue to put together your applications, especially in this time, in this present time that the policies of the Home Office are becoming more and more tight. The environment is becoming more and more hostile to immigrants. The decisions of the Home Office are becoming more and more, sometimes very, very deeply irresponsible and unreasonable in some certain circumstances. Now, this is the era whereby you have to macroscopically look at the decisions. You have to painstakingly make that application to make sure that that unreasonable decision will not come out. It will not come out if the application is made with the policies in line, with the Home Office guidances in place, and with the case laws together, injecting into it, and at the same time flavoring it with the statute. then in that case, you presented a perfect application, a perfect appeal that will be plausible, that is completely plausible, that is not a waste of time, that is not a waste of space, that is not a waste of money. Therefore, that's what Tice Madox Solicitors will do for you. That's what I will do for you. We maximize your fee. We make sure that your fee is put in the right perspective, in the right use, in the right frame, so that your fee will be an advantage to you when the decision is made on your behalf. Listen to me. What I present in this program is not legal advice, but it's trying to bring your consciousness. It may not apply to you, I always say that. It may apply to someone you know, your friend, your cousin, your neighbor, or even someone talking about it on the train, or you heard over it. You can as well say, listen, go to this place. You signpost them to Tice Madox Solicitors. This country runs on the perfect issues and lines. If you argue within the issues and lines of argument, you will succeed. But if you are arguing broadly and generally, or in a generic format, you will not succeed. Rather, you will be chasing the judge, towards really getting fed up with your case, because he will not really understand the issues of which you're arguing. So arguing issues are very crucial. But if you do these things yourself, you're permitted to do, but I can tell you, you don't want to do that a second time. It is very important that it's presented to you from the beginning. When we handle your case from the beginning, we have injected all what is required and laid a solid foundation for success. And that we will build on in the event that a caseworker is so unreasonable to refuse. By the way, they will not, because the argument will be done straight to the issues and fortifying it with the case law, status, policy arguments, and guidance, explanation, and interpretation. That's why my topic today is Home Office policy/interpretation. Now, the reason why I took time to explain the policies of the Home Office and how it affects your application in line with immigration rules is as a result of the powerful authority given to the Home Office to interpret the rules through their policy, which they gave to the Home Office caseworkers. The caseworkers themselves may not be completely versed with the rules, or completely versed with the statutes, may not be completely versed with the case law that has just been released in 2017, as a matter of fact. And because they have so much case law they're dealing with, some of them completely forget the fact that they need to cross-check the application made before them in line with the recent case law that are either in favor or is not in favor, especially those that are in favor of you, the applicant. That's what I'm concerned with. The Home Office, because of the so much voluminous work they deal with and caseworks they deal with, they forget that and they focus primarily on the policies which the Home Office have given the caseworkers in making sure the applications are dealt with. Now, these applications are dealt with either within the rules or outside the rules. So the policies guide the Home Office caseworkers, but sometimes they get it wrong. And not just sometimes, in the majority of cases, they get it wrong because they're in a rush to make a decision. They're always in a rush to refuse. I said, let me point this out clearly to you. This 2017, the Home Office, as a matter of fact, let me start from December 2016 upwards to this present 2017, the Home Office decisions have been very unreasonable. And when I say that, they've been unreasonable in the sense that they seems to have a very technical way of refusing application, just go on appeal. And in that case, take you to a long waiting list on the upper tribunal or on the first tribunal, or primarily even refusing the application, given the fact that they have the power to refuse and return first and appeal from there. Then in that case, even the very minor issues that they should grant or they should overlook or they should ask for better information, they refuse on that ground. And as a result of that, it will give you right of appeal outside the country. So in that case, they have achieved all they need, which means refuse you and send you out of the country to appeal from there. And they know that majority of cases out of 100%, clearly almost 95% that are given right of appeal outside the country do not appeal. So in that case, you do not have any more ground to stay here if you do not go by way of judicial review. That means any decisions, anytime the Home Office accustom you, that will be a detention. Because in that case, you have exhausted all that you need to have. Your appeal right, you have not taken it. That you have exhausted the judicial review period, which is 3 months and it's gone. You've not applied for judicial review, obviously. And even at that, judicial review is not a bar to removal. But sometimes, depending on the argument made, sometimes the Home Office may not remove. But it is not a bar to removal. But it's certainly a very important factor to take in if you're not appealing from outside of the United Kingdom, from your home country, if you're removed. Now, back to the topic, home office policies / interpretation. What do I mean by that? Now, the policies of the home office are subject to interpretation by the court, by the tribunals at courts. They are subject to interpretation, which is why I love this law. I love it so much because the fact that you've said something is not the end. So nobody is a Caesar unto themselves. Nobody is the final arbiter unto a decision they make. No. What decision you make is subject to interpretation. Your decision you make either as an employer, decisions you make either as a business manager, decisions you make either as a co-contractor, decisions you make as in partnership in a business, decisions you make are subject to interpretation. Even decisions you make as a parent to your children are subject to interpretation. Even the decisions you make in your will are also subject to interpretation. So nobody has the final arbiter of decisions. The final decision and arbiter of that decision lies with the court. That is why it's called civil. That's why it's called law. The law will look into the both sides of the coin to see whether the decision you made is actually correct or not. That means it's subject to challenge. And that is why before that decision is made, it's married together in line with the law to make sure that if challenged, you will still be on point. You will still be correct. That's why Tice Madox Solicitor will guide you. But I can tell you, home office decisions are subject to interpretations. Home office policies are subject to interpretations. The decisions are subject to appeal, whether by judicial review or by right of appeal. We have succeeded tremendously in achieving the result. Let me tell you this, and it's very important. You understand this clearly. Don't make no mistake about it. Decisions of the home office are subject to what? Interpretation and appeal and review. So do not walk away and the decision of the home office made to you and you now put it on the carpet or even destroy the decision and then walk away and say they refuse me. No. I know some of you have the challenge, the difficulty of financing the challenge against the home office. But if your case is right, which is why I said from the beginning, if we handle your case from the beginning, as I said, let me say this. If your case is handled from the beginning and done properly well, the essence of you chasing a wild goose chase on appeal or judicial reviews will not be essential because all the ingredients that's needed to succeed in our application, all the arguments, all the policy argument, case law policy argument, case law argument, statute argument are already blemished and embedded in that application we make for you. And therefore, if a decision is made against contrary to the argument put in that application, therefore we succeed straight upon it because the essence of that application argument is to secure you first, if the home office are reasonable, to secure you in contrary of appeal. Even if in contrary of appeal is not given, to secure a perfect and sound judicial review decision. But that's what it means. If you just make your application yourself without just making the argument that's required, without even knowing what the case law is talking about or statutes are talking about and refused, and because you want to buy time, you go for a judicial review, absolutely a waste of time. Let me tell you now why the policies of home office are also subject to reviews. Part of them is that if you make that judicial review application without any ground, unreasonably make that application, and it's refused, and then you are slammed with cost, that cost you refuse to pay it simply because you have no leave to remain in the United Kingdom, and then 2 months' time, 3 months' time, or 1 month's time, your circumstances change, you make an application again. Failure to pay that fee becomes a ground for refusal. Ladies and gentlemen, we are vast. When we deal with your applications, when we sit down to analyze your case and advise you accordingly, consultation is very crucial. That is the fundamental part of your application. That is the beginning part of your journey. The success of your journey is embedded in that consultation. When we consult with you and clerk you, your circumstances are laid bare. Even things you think is irrelevant will bring it to your fore because that will be what is required to make sure that your case stands differently from the previous decision that is against that appellant or that decision that is not in connection and conjunction with your application, but your case-by-case basis, either circumstances within the UK or your circumstances outside of the United Kingdom, probably from your country of origin. So such decisions and such circumstances will be put together and escalated and prepared in such a way that it will make sense to the listener. It's not about telling the stories. Some of you tell some really baseless and groundless stories. Such stories are completely a waste of space. But such stories need to be fine-tuned in such a way that it is reasonable. Some of you, because you are not versed in fine-tuning your circumstances, you just say it as you want to say it. Common man saying it, not knowing that you are saying a common man thing within a restricted region, which is the law, which means that your case had to be plausible, your story had to be plausible, had to be believable, had to be in line with what is already in place. So if you just tell just normal stories, that is not enough. Simply because you just want to push in something there. What Tice Madox does for you is not just to push something in there, it's to make sure that what you push in there and what your application you make to the Home Office succeeds. That is what we do for you, ladies and gentlemen. Home Office policies / interpretations. Now, let me go to the other part of this topic, interpretation. The interpretation of the policies of the Home Office is subject to interpretation, or the policies are subject to interpretation by the Court of Record, from the First Church Tribunal, Immigration, up the way to the Upper Tribunal, and even in the Judicial Review in the High Court of Justice, and also to the Court of Appeal and the Supreme Court all the way. Such policies will be reversed if they are seen to be, one, unreasonable, seen to be disproportionate in certain regards and circumstances. And sometimes the court is very careful not to completely erode that policy completely as a whole. Sometimes the court will be very wary because of the public interest, because of the public decision or the past decisions that have been anchored on that policy. So the Court of Record and tribunals will always be mindful to streamline that policy that is disproportionate to the case before them, a case at hand. So as a result of that, you can succeed with such interpretation of the policies. The guidances of the Home Office, sometimes the Home Office do not even comply with their own policies. Can you imagine that? The Home Office will set out, because let me tell you, there are up to more than, I would not even be able to count the policies of the Home Office that are there before the caseworkers. They are so huge. Different policies, they are updated on daily basis. They are updated on monthly basis. They are updated on yearly basis. And because of the volume of work they deal with, the caseworkers, be it the junior caseworkers, the supervisors in the Home Office, could not even grapple with these changes. They fail at times to apply their own policies. And guess what? Not only is it a grant to appeal, it's a grant to judicially review, it's a grant to challenge that decision. Yes, it is. But how would you know if you don't know what the guidance is talking about? How would you know if you do not come to Tice Madox Solicitors to bring out these policies and look at the decision line by line to ensure whether it complies with the policy or it complies with the guidances or with the statute or with the case law at the moment the decision was made? That's very crucial. The date the decision was made, we'll use that to marry the time the policies were chunked out to see whether it is within the time the decision was made that the policy was upgraded, repealed, or amended, or a new one chunked out by the Home Office. And even the caseworker failed to recognize that and to use the guidances to determine your application. Yes, in this time, there's a lot of unreasonable decision by the Home Office. I can authoritatively tell you that. A lot of wrong decisions and unreasonable decisions anchored on disproportionate decisions of the Home Office. They are subject to interpretation. Tice Madox Solicitors will stand to look at these decisions line by line on case-by-case basis and decide where to breach those rules, those policies, those guidances, and amend them accordingly. Ladies and gentlemen, I've been discussing Home Office policies / interpretation. The court will interpret the policies of the Home Office. Home Office policies themselves, they will not even implement their policies in deciding your application. Then, that is why when we make the application for you from the beginning, from the cradle, we make sure that the policies, the guidances, the statutes, and the interpretations is well presented and laid bare in that representation we make for you. Make no mistake about that. And once we do that, success is guaranteed. In any event that Home Office becomes so unreasonable and take a hard line to refuse the application for completely flimsy and unreasonable reason, then we stand 100% chance to obtain it. The only thing the Home Office will succeed in doing is to delay you for the time being. But while that time tarries, we are already succeeding for you. Tice Madox Solicitors are very vast and we are experts in criminal matters. That is why we offer free legal advice at the police station, or legal aid. We have a contract with Ministry of Justice, through the legal agency to represent you at the police station free of charge. You know that. Free of charge. Free of charge. What you need is the number on your screen. And then we will come to the police station and represent you from the beginning, remember, from the cradle, from the foundation, we'll deal and put your case in proper perspective. From the police station to the magistrate court, to the crown court, to the high court, in the way of challenging decisions by way of case stated, all the way to the court of appeal and to the Supreme Court. Ladies and gentlemen, we can offer free legal aid for you in criminal matters. Pass the telephone number, save it on your phone. You will need us. You will need us. You will need us. All the way to employment matters, whatever it is in employment, all the way down to family matters, all the way down to contract matters, very important litigations in the county court. You have us. You have us to represent you to the high court at a very less expense. Even before we get to that point, we'll make sure that we exhaust negotiation on a win-win basis for you in such a way that you win without even going to the county court. We will argue that for you. We will make sure that your case is well presented for better argument and dispute resolution in the first beginning, and you don't even need to take the next step to go to court. All the way to these matters we deal with, they're on the screen. Log us, watch us as well on our YouTube, Tice Madox Solicitors. Subscribe to our TV program there on YouTube channel. Also join us on Twitter at Tice_Madox. And also on our Facebook, Tice Madox Solicitors, and watch our programs and also our comments on there. Ladies and gentlemen, our website is there, www.ticemadox.com. Go in there and check out what we do, ladies and gentlemen. I've been speaking on immigration today, and the topic is Home Office policy/interpretation. This is what you need, and the telephone number is what you need. Ladies and gentlemen, till next time I come your way, I do not have much time. I wish I could. I wish I have. Ladies and gentlemen, but the most important thing is the number that is on your screen. Give us a call, come to the office, and we'll sit down and discuss your case. Discuss your case in detail. Ladies and gentlemen, till next time I come your way, I remain Justice Maduforo, your preferred solicitor, and of course, your preferred firm, Tice Madox Solicitors.
Tice Madox Solicitors is results-oriented, but with a distinctive approach tailored to our clients' needs in our specialist fields.